What we were trying to do is realize the law school, the law library's interest in this kind of public access mission, provide this case law online so that lots of researchers, scholars, the broader public, entrepreneurs could have access to it, read it, study it, do useful things with it. That was our inside the law library, that was our entire motivation. Obviously, Ravel, Daniel, its investors were coming from, a commercial standpoint, but I think also believed in the mission for sure. What we had to do, and it was very difficult, was to strike a deal that served both of those interests sufficiently so that we'd stick to it.
Today on LawNext, March 1st marked the culmination of an ambitious and somewhat audacious project to provide free and open access to all official court decisions ever published in the United States. Called the Caselaw Access Project, it came about through an unusual partnership between Harvard Law School and a Silicon Valley-based legal research startup, Ravel Law. The project involved scanning nearly 40 million pages from some 40,000 law books and converting it all into machine-readable text files, creating a collection that included 6.5 million published cases. Harvard's Library Innovation Lab completed that digitization in 2018, making those cases available for free to the general public. But until March 1st, any commercial use of the cases was restricted by the agreement between Harvard and Ravel, and subsequently LexisNexis after it acquired Ravel in 2017. Today on LawNext, we're going to take a look at the inside story of the history of the Caselaw Access Project and talk about the significance of this final lifting of all restrictions on the data. What does it mean for the future of access to law and legal research, particularly in the face of generative AI? To help us do all of that, I am joined by three guests who all played instrumental roles in this project. Let me introduce them. First, Daniel Lewis, the co-founder and CEO of Ravel Law back in the day, who is now CEO of the contract review company Legal On. Daniel, welcome to the show.
Thanks, Bob. It's great to be here.
And Adam Ziegler, the former director of Harvard's Library Innovation Lab and the Caselaw Access Project. Adam, welcome back. You've been on the show before.
Thanks. It's great to be back.
And Jack Cushman, the current director of the Library Innovation Lab. Jack, welcome to the show.
Thanks for having me, Bob.
And as for me, I'm Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to today's conversation, please take this moment to learn about the sponsors whose generosity supports this podcast. Ditch manual billing and experience a seamless billing solution with Bill for Time. Bill for Time's user-friendly platform streamlines all aspects of the billing process, from standardized invoicing and customizable templates to built-in payment processing with Bill for Time payments. Bill for Time accelerates the payment process by up to 70%. Find out more about how Bill for Time can enhance your law practice by visiting them at billfortime.com. That's bill, the number 4, time.com. Now on to today's conversation. Well, with those introductions aside, let's turn to the conversation. And I wanted to kind of start back at the beginning. And Daniel, you were there at the beginning. You were probably involved in this before anybody else on this call was. And you, at the time, you were the CEO and co-founder of Ravel Law, which is a legal research startup. What was the genesis of this? How did it ever get started in the first place?
Yeah, so when we started Ravel, it was with the inspiration that we wanted to build better legal research and analytics tools. And we wanted to do that, we needed access to case law. And at the time we started the company in 2012, we thought that there were very positive signs that government and different court jurisdictions were starting to release case law in a digital format that would make it easier for us to suck that material in and build powerful software on top of it. So we started the company thinking that we'd be able to ride that wave of open access. And it turned out, after working on it for 6 to 12 months, we quickly learned that we had been overly optimistic in what the courts were going to do themselves. There was access to some information, but it was very patchy, both in terms of what was being released on an ongoing basis from courts just in 2012, but even more so what was available historically and what you could access from the mid-1900s or even earlier than that. So we quickly realized that if we wanted to build a great legal research platform, we needed to find an additional alternative source of comprehensive case law. And so we started casting about for where that might exist. And we spoke with the library team at Stanford, which was our alma mater, but they had already disbanded the collection essentially as they had gone digital in the library. And the collection of case law reporters really was not comprehensive anymore. And we then bumped into the team at Harvard, and Jonathan Zittrain, who was leading the library at the time, had been a professor of mine, and we'd stayed in touch a bit. And Jonathan was also kind of interestingly pursuing a bit of case law digitization because he had an idea around creating digital case law books for students. And so the library had, I think, taken some initial steps at scanning a small number of books, and he was starting to think bigger about what that could look like. And so when we met to first kind of share these two different things that we were working on and why digitization of case law was important to us, that was sort of the spark from which everything else we later built.
So, and maybe I should also add that all of us were at an event last week at Harvard that kind of celebrated this restriction, this lifting of the restrictions on the case law access database. And you were there, Daniel, talking about some of this along with Nick Reed, your co-founder, and Jonathan Zittrain, who was there. But how did it go from that kind of initial discussion to actually saying, okay, let's work together on this?
Yeah, so I think at one of the points that we met with Jonathan, he was out in the Bay Area, and I think he was in part a little bit on like a fundraising junket. He was starting to look around for folks who could potentially fund a more ambitious digitization effort at Harvard. And Nick and I met with him, and we thought about that concept, and we were working in the offices of one of our venture investors, and one of the investors kind of wandered by the room as we were talking this through. We said, look, we're considering this opportunity really, like, what if we were able to raise enough money, the millions of dollars required to fund this digitization? And the investor was like, I'd write a check for that. So that was not a done deal at that point. There was a lot of work that then followed, but we said, okay, there's something here. There's obviously excitement from an investor perspective. If we could make this easy and sort of write one big check for Harvard, that would solve a problem for them. Now, how do we make these two visions that are headed in the same direction, but have different interests? Like, we had a commercial interest, Harvard had a public access interest. How can we align those things in a way that's going to work for both sides? And so Adam starts to enter the story, I think not too long after that. But yeah, it was that kind of starting to think about how do you actually raise $6, $7, $8 million for a project like this? Who cares enough to fund that kind of work and to sustain it over time?
Yeah, well, Adam, as Daniel said, this is about the time around 2015 when you came into the picture, and you were a little dubious at first, right?
Absolutely, more than a little dubious. So I joined Harvard right at the beginning of 2014. Things were well underway in terms of the early conversations between Ravel and Harvard. I practiced as a litigator for 10 years. I remember vividly a judge in court telling me I had to provide paper copies of all the cases I cited because she and her clerks couldn't access the law. This is a prominent judge in Boston. I had my own startup where we faced this issue of it just was virtually impossible to get enough access to the law to do the kind of things we wanted to do. So I joined Harvard really because I was intrigued by this project. And when I first learned about the project, I had no idea there was Ravel. I had no idea Ravel was involved. I knew who Ravel was. I knew who Daniel and Nick were, but didn't know there was anybody other than Harvard involved. And I have this crystal clear memory from one of the first interviews in the law library with Kim Doolin and Suzanne Wones, where they told me for the first time that, this was all going to be funded or, done with the partnership of a, VC-backed startup, Ravel. And I was like shocked and alarmed and sort of just a little bit disgusted, I'd say. I was very naive at the time about how these things can actually get done and just thought, Harvard would write a check, what's the big deal? But as I, worked closely with Daniel and Nick and lots of folks at Harvard and started to really grasp the complexity of the project and the different dynamics at work and the types of obstacles we'd have to solve to really do this together, I came to, really appreciate and value the ultimate partnership. So we can talk more about that. But yeah, I definitely came into it at the outset with some deep skepticism, but that sort of thawed out quickly over a few months.
And just to further set the stage, Jack, you weren't the director yet at that point, but you were already there around that time, as well, right? You're there as a programmer at that point, or what were you doing at that point?
That's right. I was there as a programmer, but I didn't really come on the stage for the Caselaw Access Project until the data started flowing in, and we started to face the question of, well, what do you do with the case law of the United States once you have it? And that was a big responsibility from our perspective for Harvard, because the deal that Adam and Daniel ultimately struck had this long commercial exclusivity period where if people were going to get access to the case law, we were going to have to build it. So it wasn't just posted online and let the world figure it out. It was figure out how to put it in a form where everyone could use it and benefit from it within the restrictions of the contract. So as a lawyer and a programmer, that fell on my plate to say, how do we get this out to the world and make it useful?
So talk about that deal a little bit, just so that listeners can understand what it was that you ultimately agreed to do here. Adam, I forget who it was. Somebody at the program at Harvard last week kind of described you and Zitron as kind of good cop, bad cop on this deal, with you being the bad cop, I guess. But what were the ultimate terms that you settled on?
Yeah, so, what we were trying to do, as Daniel mentioned earlier, is realize the law school, the law library's interest in this kind of public access mission. Provide this case law online so that lots of researchers, scholars, the broader public, entrepreneurs could have access to it, read it, study it, do useful things with it. That was our, inside the law library, that was our entire motivation. Obviously, Ravel, Daniel, its investors were coming from, a commercial standpoint, but I think also believed in the mission for sure. And what we had to do, and it was very difficult, was to strike a deal that served both of those interests sufficiently so that we'd stick to it and we'd, put everything we had into it on both sides. We also had to take some compromises both sides and get comfortable with some things that maybe weren't ideal, but we knew in the longer term were good for us, good for the missions we cared about. So at the end of the day, after many, many months of very complicated and difficult negotiations, difficult because of how complex, not because there was animosity. But we landed on a deal which essentially had Ravel agreeing to fund the work to scan and convert the scanned images of all of this case law into machine readable text data. The Harvard Law Library would do the work of scanning, and that was done literally physically inside the law library by a team of librarians and others, right there on site. And then the resulting data, after it was processed by a vendor, certain things were redacted. The resulting data would go to both of us. And Ravel would have certain privileged rights for roughly 8 years to exploit that data commercially. Harvard would have lots of rights to use the data for public interest and for scholarly interests, as long as we prohibited people from making commercial use of it for that time period. And we constrained the amount of case law that certain types of folks could get. So you could only get 500 cases per person per day, for example. And we basically would pursue these interests in parallel until this moment arrived. And the moment is the one that arrived, a couple of weeks ago that we're all celebrating, which is that all the restrictions, all the exclusivity would disappear and the data would go fully publicly available without restriction by March of 2024. The only other thing that happened there were a bunch of other terms. I mean, the deal was super complicated, super long, way too complicated. But the other thing that happened was Ravel took on the obligation to itself make available for public benefit this data. And that was really important to us because frankly, we didn't know. I mean, Jack hadn't been persuaded yet to join the team. He wasn't, he was working on other stuff. So we didn't know precisely what we could do internally at the library. So it was really important to us that Ravel take on the commitment to deliver some version of public access as well. They took that on, agreed to those terms, and eventually we had a deal.
Daniel, you want to add anything to that? I mean, it's such an unusual kind of a partnership between this startup coming out of California and this, established Harvard Law School institution out on the East Coast. How did you view this deal, and what was your perspective on it?
Yeah, Adam gave a really good recounting of it, but I could add maybe a couple pieces. So just in terms of how it was structured, we approached the deal in two pieces. The first was negotiating essentially an MOU where we said, and that was a relatively short document, but it started to expose the things that would need to be a lot more negotiated in the definitive agreement. So that first MOU I think it took around 9 months to get done anyways. And with that, we were then able to go out and start to secure the next round of funding that would be used in part to actually fund some of the digitization work. So after we finished the MOU, we sort of knew what we needed to flesh out, and we got to working on the definitive agreement, which then took I think it took 18 months to negotiate. In part because, as Adam said, we ended up negotiating about a lot of things that ultimately didn't matter because you're negotiating around contingencies and hypotheticals and risks that could happen. But it was everything from, how will payment flow as the execution moves along? It'll be organized around milestones and check marks and progress indicators. How will we handle the data as it's what exactly will be redacted from the data? Conversations around that. These public access aspects of it, as Adam touched on. What will Ravel do? What will Harvard be able to do? So all these sort of intricate bits and pieces where I think one of the hardest parts is as a startup, we had a very high risk tolerance because we're a startup, and Harvard had a very low risk tolerance, right? So you have a mismatch there of very conservative and very aggressive, which just took a lot of time to try to mesh up and to do it it's not that there was ultimately so much that was at loggerheads, but it was how do you do this deal at a pace that works for us as a startup? Because Harvard was kind of moving at a different pace. And that was one of the tensions as well. As Adam and I and Jonathan and Nick got together last week and did a panel about this, I'd gone back to some of my emails to try to recollect on the thread. And one of the emails I found was, we were probably 15 months into negotiating the definitive agreement. And I wrote what in hindsight looks like a very desperate email to Adam and Jonathan being like, guys, I think we're basically agreed on all the terms. Can we have this deal done in the next week? Our investors are breathing down our neck. If we don't get this done, I don't know whether we're going to get it done. And so even with that level of desperation, the deal was only signed, I think, 3 months after that. But it was sort of that constant level of trying to push this thing forward was recurrent.
Yeah.
And, what's interesting about that is on our side inside Harvard, we're just a team in the law library that can't speak for all of Harvard. And, we were essentially doing kind of a multilateral negotiation with both Nick and Daniel at Ravel, but also with just a huge number of people who had jobs to do and certain priorities inside Harvard that had to eventually approve and get comfortable with the deal. And so it was very much part of the day I'd be talking to Nick and Daniel, talking through some of these mechanisms of public access and payment and milestones and everything. And the other part of the day, I'd be talking to risk managers and other folks at Harvard who had, different things on their minds. So that's what made it so complicated, and it took so long. And there's more than once I thought, all right, Nick and Dan are gonna bounce. They're not gonna last much longer here. They're gonna have to give up at some point.
Yeah, that's interesting.
But they didn't.
Yeah, you talk about selling it within Harvard, and Daniel, I was surprised that you said it was so easy to sell to your investors, because I would have thought your investors would have said, "Are you crazy? We're going to put all this money into something, and we're only going to have the commercial rights to it for this limited period of time." I mean, how much of a point of contention was that, or was that not?
I think it wasn't that contentious on our side. I mean, as Jonathan reminded me, I guess initially we asked for something like 50 years of exclusivity, and Harvard asked for 0, and we met we met closer to Harvard, if you look at it in that terms. But I think our thesis had essentially been, look, we would be very happy in a world where all of this information was publicly accessible. Because what we saw, our strength as a software company was not really collecting the law. It was about how do you build the best tools and interfaces and make the most value on top of it. And so doing the digitization was a total, Jonathan called it shaving the yak or something. It's like, first you have to do this thing and then you have to do this thing and then you find yourself shaving a yak. And that's what it was for us. It was a project that only did almost reluctantly because we had to. But our end goal was this could be available to everybody. And we still think if we're not building the best software on top of it, we don't deserve to win. But we did need to secure some commercial exclusivity just to make it make sense. Otherwise, there was no good reason for us to fund it versus anybody else. But that ultimately, wasn't the most contentious piece of the puzzle. And it's funny too, now looking back, 8 years at the time felt like a very long time. Now that we've reached that date, it doesn't feel like it's been actually all of that long. And so I think that's an interesting mindset too, that I think I've appreciated more as I've matured and been doing this in this space a little bit longer, which is things do take a bit longer than you think. More, it's that sort of old expression, you sort of overestimate what you can do in 1 or 2 years and you underestimate what you can do in 10.
So far in this conversation, we've focused on the unique deal that allowed the Caselaw Access Project to get started in the first place, a partnership between the Harvard Law School Library and a Silicon Valley legal research startup. But then the real work had to get done, the work that, as you'll hear Adam Ziegler say in the second part of our conversation, he is still most amazed ever got done. And once that work did in fact get done, what did it all add up to? What is the significance of this project, and what will be its impact on access to law? We'll talk about all of that in the next part of the show, but before we get to it, please take a moment to learn about the generous sponsors who support this podcast. Say farewell to outdated spreadsheets and say hello to a new way of managing your legal cases. Bill for Time's customizable legal practice management solution helps you easily track time, automate billing, share documents, and so much more, all within one platform. Take your practice to the next level and focus on what matters most. Visit billfortime.com today to learn more. That's bill, the number 4, time.com. Welcome back to LawNext. We're recounting the story and the significance of the Caselaw Access Project, an ambitious and audacious project to provide free and open access to all official court decisions ever published in the United States. My guests are 3 of the individuals most directly responsible for making it happen. Daniel Lewis, the co-founder and CEO of Ravel Law, who is now CEO of the contract review company LegalOn. Adam Ziegler, the former director of Harvard's Library Innovation Lab and the Caselaw Access Project. And Jack Cushman, the current director of the Library Innovation Lab. By the way, Daniel's co-founder at Ravel, Nick Reed, who's now Senior Vice President of Product R&D and Design at Knowable, was also scheduled to join us, but had to cancel due to a last-minute conflict. Lots more to talk about, so let's get back to the conversation. So one other thing I wanted to ask about the sort of the deal overall is that at some point after you had this deal in place, and as the project was underway, Ravel got acquired by LexisNexis. Was that a wrench in the works at all, or was it just business as usual at that point? How did that acquisition play into this overall process that was ongoing?
When we did the definitive agreement between Ravel and Harvard, obviously there'd been a lot of anticipating that an acquisition could be an event, right? So it was not a surprise from sort of a contractual standpoint. We had all the right mechanisms in place to deal with it. And ultimately, I guess from my view, Adam might have a different one, it ended up going pretty smoothly. Lexis took on the obligations, the team at Ravel continued to manage the relationship by and large for the next several years. And it wasn't a blocker to the deal. In fact, I think in some ways it added value to the deal. Lexis saw aspects of that data that it didn't yet have, things like original scans of cases that it didn't have original scans for. and filling in some of the gaps in its own collection that it had previously almost not even been aware of. So there was value add from that perspective, but there was also, taking on of the obligations and the fulfilling of them that ultimately, satisfied the terms.
Yeah.
Maybe I could share just a bit of our perspective on the same question. We definitely focused very, very heavily during the contractual part on the likelihood that, Ravel with great technology, with great founders, investors would likely be acquired by somebody big, possibly somebody who didn't have the same commitment to the goals of the project. And so a lot of what was in the contract was designed to protect the project in the event of that kind of acquisition. And, I feel really good in retrospect about how that turned out because the project was protected and nothing got in the way and there was no kind of opportunity to squelch it or to interfere with it. But I do think once the acquisition closed, that at least our thinking was a little more in the direction of, all right, we're going to need to figure out how to provide some access to this data. We're going to need to, who on our team, obviously, ultimately that was Jack, could help really unlock this data. It's going to be harder for us to depend on or rely on or even really communicate with folks at Lexis now who would be able to get this done. So I was thankful that we took care in the contract to prepare for this. And, we kind of shifted our emphasis at this point to, all right, what could we do inside the library innovation lab to make this data have some real impact?
So this all started back in 2015. By 2018, you'd had the scanning pretty much done, and you began to put this information up, make it available to the public, still subject to these commercial restrictions. But what's interesting is that you've got Ravel giving you all this money to do this massive scanning and digitization project, but you'd never really done a massive scanning and digitization project before, right? I mean, how did you get from point A to point B? I mean, what was that process like of beginning to figure out how to do this and executing on it?
Yeah, I mean, it was, I look back on this, and this is kind of the thing that I'm most amazed happened. The contract was hard. A lot of stuff was hard. All the code was hard. But this physical work of scanning these 40,000 books was really the thing that probably shouldn't have been possible. And we did have inside the library, a bunch of people who really knew the work of digitization. They were real professionals in digital collections, in digital preservation, in scanning, all of these kinds of things, but not at anything close to this scale or at this speed or under these circumstances. And so what we ended up doing, while we were working with Daniel and Nick to hammer out this agreement, we had so much time, to work out the agreement. We were also running essentially a proof of concept inside the law library on a smaller universe of materials. And that allowed us to kind of figure out, to learn, to model everything we would need to be able to do the full project at scale. And so it's a really, wonderful story from my perspective of just a bunch of hardworking, dedicated, expert librarians inside the law library caring to see this done and really working together to figure out. And we had to solve so many little problems from, all right, what equipment do we use? Where do we put the equipment? How do we get all these books? The books weren't in the library. They were at the Harvard Depository 30 minutes away with lots and lots of other books. We had all these little problems we had to solve and figure out. And, it's hard to credit everyone who had a role in that. But, we had everyone from Dean Martha Minow of the law school, who was really supportive and encouraging all along the way for this project, to Suzanne Wones and Kim Doolin, who led the library and really helped marshal resources to make the project happen, to people like Carolyn Walters, Karen Beck, who were experts in the collection and helping us kind of flesh out the collection and figure out what we had to scan, to people like Lindsay Dumas, Steve Chapman, Carrie Fleming, who really mastered the work, the assembly line, if you will, to scan this work and get it up into the vendor's hands so they could process it. So it's really a really wonderful story of roll up your sleeves, do something, figure out how to do something together, and make it happen. And it's kind of the thing I'm most proud of if I look back on the project and all the work we did to make it happen.
Jack, what about from where you were sitting at that point and thinking about how to begin to use this data and, I don't know, create metadata around it all, whatever else was involved? What were the challenges that you saw in making this come about?
Sure. Well, and first of all, I think a lot of credit is due to Andy Silva, who was a developer on the team, building the software that made the digitization itself possible. So every step along the way and all of that coordination had software behind the scenes, custom software written to track it and make that possible as well. And I was fortunate to come in after that. So I came in when the results started to come in. And all of a sudden we have a collection on the Amazon cloud of 7 million case files and 40 million images and 40 million OCR page scans. And you look at it and say, great, we've done access to law. This is it, right? We just have to press share and we're ready to go. And the truth is that's very, very hard to go from that to something that people can really use and make sense of. So our strategy was to start with the data and work out towards the interface because that was the simplest thing for a small team to do. So the very first thing we built were the bulk exports that we were allowed to share with research scholars. So we got here's the files in a readable form, and we can share these with the first people who are going to start doing academic scholarly research with it. After that, we built an API. So we had all of the code in a database and a website front end that only programmers could love. You couldn't look at it and as a regular person use it to read the law. But if you were a computer programmer, you could build applications against it that could read the law, and people started doing that. And then the next layer around it was our own front-end interface to it for people who more like to point and click than write computer programs. So building our own search tools, our own display tools, but all using our APIs to keep us honest so that we knew that programmers could keep using the data because we had to make the APIs work in order for our own interfaces to work. And then the last layer I'll put on, because we're an innovation lab, was the art layer, that we wanted to help people be able to imagine what was different about computational access to law than database access to law. If you talk to lawyers, they may well say, well, I've got Westlaw, I've got Lexis. Is this cheaper, or what's different about it? And I would say, no, it's fundamentally different because this can be on your computer and it can be anything that you want it to be. And that takes a while for people to think about that difference. So one of my first art projects was a limerick generator, where I indexed the entire 40 million pages by a rhythm and end rhyme of every sentence. And you could press generate and get a 5-line limerick drawn from lines of case law. That is useful to no one in the world except me. It made me happy.
It was fun, though.
And that was really the point. Yeah, it was fun. But the point was to say, look, if you can make a limerick generator with this, then you can make absolutely anything with it. And I think that you can make absolutely anything is meant to inspire the real useful novel applications of the data. Like we talked about Justin Simard at the conference, who worked on the Citing Slavery project, where he's tracing the influence today of cases that were decided before the Civil War, when humans were wrongly treated by the law as property, and that property legal analysis flows through to cases that are still alive today. Doing that kind of analysis is very similar at the technical level to doing the analysis, like how do we generate a limerick? But I wanted to have those first artistic experiments to start to get people thinking that way about the cases as data.
Well, one of the other things I think you developed was the historical trends viewer, which was, I don't know if you consider that another artistic example of how to use the cases, but that was a really interesting application of it.
That's a perfect example of something that's both artistic and really useful. So this was inspired by the Google Ngram viewer. Well, Google will let you view the frequency of words over time in the collection of Google Books. And we said, well, let's have something like that for cases, so you can see the frequency of words over time in the case law. And it lets you really run your hands through the cases in a different way than you've ever been able to do before. So you can look at the frequency of the word pirate and see the pirates of our cases from the 1700s and then the pirates of our cases from the 2000s once Napster was invented. You can compare he said and she said and see the early case law that didn't have representation from women and how that starts to change. You can look for data patterns in there. There's a fascinating pattern that the word victim wasn't really used in case law before the 1960s and 70s. And we don't actually know why. It's a sort of enduring mystery of the data that popped out. There have been victims in criminal law the whole time, but courts didn't talk about it that way. And so we saw both people would use it just because they were curious. What are the words that I like horses, so how are horses talked about in case law? But also law professors would use it to say, see, I told you that people started talking about this differently, and I just ran this search, and you can see that I was right.
Yeah, Daniel, I'm curious. What were the sort of the ultimate implications for Ravel and then of Lexis of having access to all of this case law data? Did you actually use it in some commercial way? What happened to it on your end?
Yeah, so I think in some ways it fulfilled its mission, and in some ways it didn't. When we had access to all that information, it did make us a much more credible research platform. And we were able to build much more trustworthy search on top of it. We were able to start building judge analytics that could go very far back in time. But, I think we also realized that for legal research, you do need more than case law. And what Lexis or Westlaw has is a lot more information. They've got all of the laws, they've got public records, they've got secondary materials. And so from that lens, it was not enough. It was not enough for us to be another Lexis or a Westlaw. Case law alone is not the whole game when it comes to legal research. So that was one of the, I think, challenges of, it's one of the challenges of this whole space, right? There's a lot of information that we talk about when we talk about legal research. It's not just cases. Moreover, I think one of the things that we already knew at the time, but everybody can appreciate today as well, is this was a project that was looking back, saying, how do we make a truly comprehensive collection available for the first time and solve that problem? And once we solve it, nobody's going to have to solve it again. But that doesn't solve how you get your hands on law that comes out today and tomorrow. And that problem is still, unfortunately, not really solved. And so to build really powerful tools, we're going to have to unlock that. We're going to have to unlock that because a lot of the most important insights are around what's going on recently, right? Judge analytics, for example, you don't really care that much about how judges ruled in the 1800s. You care about how the judge you're in front of today has ruled most recently over the last 6 months or a year. So there's a lot of different applications where access to fresh, current data really matters too.
So to fast forward to where we are today with the release of the commercial restrictions on this data, and I guess kind of the beginning of a new phase of the Caselaw Access Project that's perhaps maybe more forward-looking than it has ever been until now. What's the significance of this? Jack or Adam, where do you go now as you look ahead to what the potential is for this data?
Sure. I'll name a few kinds of potential. Adam, tell me what I miss. One piece is I want to see the data that we already have used 1,000 more ways because we no longer are working with the restrictions that we had. So I'm delighted that the Free Law Project and Court Listener have a copy of the data, and it's available through their API, along with today's law that they've scraped from court websites. I think as far as I know, at this moment, that is the best snapshot you can get in the open of all of the case law that's out there. And that gives us the best shot at merging the case law resources with statutes or regulations that other projects like openlaws.us are working to collect. To start to have a picture that does cover everything that can be available to everyone. So I'd like to see that part continue. Where my thinking is going as a lab, one direction is how do we start to use resources like this for legal understanding? And I think the whole legal industry is talking today about how do we build AI tools on top of the data that's out there that can answer questions for people, whether those people are skilled lawyers or researchers, or whether they're people who are affected by the justice gap, the 9 out of 10 low-income folks who, when they have serious legal issues, can't find lawyers at all. I think there's room now to use tools like this for helping to address those. So that's why our lab just released our Open Legal AI Workbench, which is a tool to start to compare solutions for legal question answering and retrieval. We're not saying, hey, this workbench does any good at all right now for answering legal questions, but we're saying if you're trying to test whether technique A or technique B is better, this is the best way to test that scientifically and share that answer with everyone. So we're looking at how do you put effective interfaces on top of this. And then the other thing that I'm thinking about is how do we make the next deal a lot easier than the last one? So when I look at the story of this deal, there was a piece that was about exclusivity, and that's huge. Whether it was 50 years or 8 years or 1 year, when you have exclusivity in the mix, you have a big piece of pie to fight over, and a lot of the conversation is about the fight and who is winning and who is losing, and that it slows you down a lot. There is a magic to 0 years of exclusivity in digitization projects, a lot like there's a magic to the price of $0 on the internet. If you can get to zero, you can open up whole new ways of doing business. And we think that's actually possible today in a way it wasn't at all when this deal happened, because AI companies are so hungry for data and so focused on techniques and algorithms that they're willing to talk about, just get us the data today. We don't care what it takes, and we don't even care who else has it, because once we have it, we can get done something really special. So we think it's the right time for the industry to come together on getting data out at that magic 0 years of exclusivity level, where it's a lot easier to get deals done. And then I think if we look at the other things that made it hard, extracting copyrighted material from each page, that's getting easier with new tools. And it's easier if you have a consortium who all benefit from it. If you look at just the logistics of how are we going to get 40,000 volumes through, that's easier if you're not trying to protect the data too, and if you have a consortium that's all invested and can get together to help. So I think there's a lot of room right now to make things like this so much easier than they ever have been. And that's a lot of the conversations and the work that we're doing these days.
Well, if you need help negotiating those contracts, I think Daniel can help you with that now with his new company. But Adam, what about you? What's your thoughts about this?
Yeah, I mean, I certainly agree with all of that. I love the approach that the lab has taken under Jack's leadership the last couple of years, and there's a lot of exciting work underway. Where I go to is back to being a lawyer, and the things that I really wanted 10 years ago that I couldn't have, but maybe now are much, much more within reach, or at least within reach of experimentation. We're going to see, in the very near future, AI-powered citators, that are looking at citations and discussions of authorities and figuring out the flagging or figuring out what the characterization might be. We're going to see classification and labeling and taxonomy and all this kind of stuff that AI does really, really well that traditionally has been just impossible. We're going to see that kind of take a big leap. And those are the things that, already existed. They just were very proprietary, and now they're going to be much more widespread. But we're also going to see, and this is what excites me the most, is just the ease of experimentation, the ease of getting started. If you have an idea, you're a lawyer, you're a programmer, you're a designer, you have an idea for what you want to be able to do with the law. It's so much easier now to try that, figure it out, demonstrate it, test it, get some feedback on it. In the same way that creating a startup is so much easier today than it was 10 years ago because of all the resources that are available, all the difficult problems that have been kind of solved. Same way with access to this legal data. So, if you're inside of a law firm and you want to experiment with linking up your internal briefs and things with case law, perhaps case law annotated in a private way, now you can build something that does that pretty easily. You don't have to just kind of keep knocking on the door of the big vendors hoping they decide it's worth it. So I'm really excited about that, blossoming of experimentation. We'll see. People have to do the work, but certainly the data is going to make it much, much easier.
Do you think we're going to see other Ravel laws coming along thanks to the availability of this data?
I think we're seeing them right now. Frankly, they're back in 2012, 2013, there were a couple of legal research startups. That was kind of a wave. It's kind of quiet since then. And now we have a whole bunch of them that are doing different things. Some of them have benefited from the ability to at least use this data on a small scale. And I think we're going to see a huge variety. We're going to see people start to think about specialized interfaces for particular practice areas or particular perspectives as a lawyer or as a lawyer serving certain clients. To me, that's really exciting. And we can think much more creatively and broadly about how to be a good lawyer, how to have knowledge of the law and use the law to help clients than we've been able to in the past.
I know we're just about out of time, but there was a question asked at the program last week, and I forget who asked it or who they asked it of, but it was basically, what are you most proud of about this project? And I thought that might be a good place to end, to kind of go around and ask each of you what you're most proud of as a result of this. And Daniel, since in some ways you were the original impetus for all of this to get going, what about you? What are you most proud of here?
Yeah, I'm proud that we've created this set of materials that, like Jack and Adam were just touching on, are hopefully going to be used in a variety of creative ways. And when we did the deal at the start, we had a particular vision for it, but we knew that ultimately we'd be sort of planting the seed from which hopefully 1,000 different flowers could bloom. And we never knew what those flowers could look like. But now that we've reached this point where through the hard work, through the effort, like we did that, I'm really proud that we did the dang thing that other folks hadn't been able to do before. I'm hoping that it's sort of a midway of a marathon. It's like we did the work, and now I'm also really excited to see what can come next. So I wouldn't say I've like tied a bow around the project. I would say that now is sort of an exceptionally exciting moment too to have it be released. Now that we've seen the power of LLMs over the last year or two, it just feels like a very ripe moment where the possibilities are more open than we could have imagined even 10 years ago.
Yeah, we're certainly not pronouncing this is not the obituary for this project. This is the birth announcement in some ways, I guess. But Adam, how about you?
Yeah, and if it's all right, Bob, I'm going to share something I'm proud of, but also a little bit of a disappointment. So what I'm proud of, I've already talked about. It's really the success of our team in the library across a huge number of disciplines and expertise and, frankly, perspectives and skepticism on the project at the outset, coming together, figuring it out, doing this really hard thing that mattered, and now being able to kind of look and see what the results are. That is, a source of great pride, and I hope it is for everyone who worked on the project as well. I'm also very disappointed. And one thing we haven't talked about is that part of the contract, in fact, and part of our aspiration together was that this work would make it easier and perhaps kind of nudge in a positive direction the courts, the judges, the legislatures in solving this problem themselves, which they are the ones ultimately that should be solving this problem. They should be publishing their law digitally in the first instance in an authoritative way with neutral citation, et cetera, so that nobody else has to come along and scan just to make the law accessible. And generally speaking, a few exceptions here and there and some progress here and there, it hasn't happened. And it still is a blocker, as Daniel alluded to earlier. And, we could only do so much. Jack and I certainly tried. We made the rounds. We talked to lots of different courts and judges and folks who were enthusiastic about the idea, but the execution was extremely difficult. So I'm disappointed that we haven't made more progress on that. I think it's doable. I'm optimistic that we'll get there in the future. But that's the one thing that kind of in the back of my head, we didn't quite figure out.
Yeah, that's an important point. You had at least one interested judge at the program last week from the Massachusetts appellate court system talking about this, so that was good. Jack, how about you?
Well, I can't resist plugging Carl Malamud's talk from the program on Friday, which, Bob, I know you also covered. I've become personally a big fan of Carl's Full Faith and Credit Act as a proposal for solving the problem that Adam is talking about. To say, hey, as Americans, as people who live here, as people subject to the law, we all deserve to have one solid, consistent place where we can all see what the law is. And that's a problem our government can solve. It's a problem it's supposed to solve under the Constitution. It's a problem that we can make a clear plan to solve. So I would love to see that proceed. And I couldn't resist throwing that in before we actually talk about what I'm talking about.
And that, just to be clear, just so listeners know, I mean, that's a proposal basically to say Congress should enact a law that says that all government entities that promulgate laws have to deposit a digital copy with the government publications office or whatever it's called, government printing office.
That's right. Yeah. That's right. And it makes sense because the states do have to give full faith and credit to each other's laws. And if you have to give full faith and credit to a law, you ought to be able to look and see what it is.
That's right.
I don't think it's asking any too much to say, hey, if you say something is a law, just give us a copy.
Yeah.
Just give us a copy so we can find it. That seems very achievable to me. So I love that idea. The thing I'm proud about, I direct a library innovation lab, and I'm a library person through and through. I'm an open culture person through and through. And so a lot of how I count my personal, karma is what did I pick up from the last generation and pass on to the next generation? What did I make that can endure? And I think we did that here. Folks on this call and the dozens of other people Now we have something that is there on the web as plain old static files where they're not going to go away. They're not going to break. They're a recording of centuries of the decisions of our courts in a format designed so that anyone can use them and so they can be used for any purpose. And that is going to endure. And there's so much of it, and it's such important stuff. I'm really proud that we made that possible, that we took it from the last generation and passed it on to the next.
Well, it was a very important project and an amazing achievement. And congratulations on this latest milestone. And Adam, Daniel, and Jack, thanks to all three of you for being on the show today. I really appreciate it.
Thanks a lot, Bob.
Great.
Thanks
you,
for
Bob.
having us on to talk about it.
My sincere thanks to Adam, Daniel, and Jack for joining me today, and a huge congratulations to them and everyone who was involved in this project for this momentous accomplishment. I hope you enjoyed the conversation. If you'd like to share your own thoughts or comments on today's show, please do so by tweeting us at LawNext Podcast or by emailing me directly, ambrogi@gmail.com. If you're a fan of LawNext, why not leave us a review? You can do it wherever you get your podcasts. LawNext is a production of LawNext Media. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of Law Next.